Hi there, I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. All right, back again with part 2, the second of 2 parts on the Chapter 13 Bankruptcy Adjustment of Debts and of an individual with regular income. We're going to cover these areas to complete the Chapter 13 lectures. As in Chapter 7, there will be a 341 meeting. There's an appointment of a trustee, in this case a Chapter 13 trustee. We're going to talk about the trustee's duties and the avoidance powers that the trustee has. The 341 meeting of creditors, what that is like for Chapter 13, and motions after the order for relief. And also complaints after the order for relief. Remember, the order for relief is that order from the court that says there is a pending bankruptcy. Hearing on the confirmation of the plan is covered in this lecture. Distribution of payments, modification of the plan after confirmation, and revocation of the order of confirmation, and full compliance discharge. I forgot, there's also, we're going to talk about the hardship discharge. So first, the clerk's notice of 341 meeting is sent to the debtor, the trustee, all the creditors, the indenture trustees, and the U.S. trustees, and they must receive, that must be sent not less than 21 days. Notice of the date and time, the location. It'll have the deadline for filing proofs of claims, unlike the 7, Chapter 13, Chapter 7, remember, the notices don't file any claims until we tell you so. Because most of those are insolvent. Chapter 13 is not an insolvency situation, and so it serves the creditors obviously will go in and file.
I didn't get that. Could you try again?
I didn't ask you for anything, Siri. All right. The clerk's notice serves as a notice of the order for relief. So this is the order for relief, and a copy of the plan or summary of the plan must accompany the notice of confirmation hearing. A Chapter 13 trustee is appointed after the order for relief is entered. The standing Chapter 13 trustee, or if there is no standing 13 trustee, another individual or United States trustee will serve as the case trustee. They're accountable for all property received, and the primary function of the trustee is reviewing the plan, advising the bankruptcy court with respect to the plan, and acting as a disbursement agent under the confirmed plan. Their duties of the trustee include investigation of the financial affairs, examining the proof of claim documents filed by creditors. They will oppose the discharge of a debtor if it's advisable. They'll furnish information concerning the estate to parties who are interested, unless the court orders otherwise, and they make a final report and file a final account. They also provide notice of the domestic support obligation, appears and is heard at any hearing concerning the value of the property, the confirmation of the plan, the modification of the plan after confirmation. And they may not advise the debtor on legal matters, but they must advise and assist the debtor in other matters pertaining to the performance of the plan. The Chapter 13 trustees' avoidance powers. So they have most of the same avoidance powers as trustees in other types of cases. so they can avoid liens and that sort of thing. We talked about that more in chapter 7. So keep in mind that chapter 7 and 13 have a lot of similarities and a lot of differences. But the chapter 13 often does choose to use these avoidance powers because the role of the 13 trustee is different from the role of the chapter 7 trustee. The meeting of the creditors is held 21 to 50 days after the order for relief, and the debtor must attend, answer questions under oath. The trustee conducts the meeting and may question the debtor. Debtors have an opportunity to question both the chapter 13 trustee and the debtor, and the trustee may give the debtor some indication as to whether he or she would recommend confirmation of the plan. That's fairly typical. So after the order for relief, the debtor may want to make some motions to convert the case to another chapter, such as 7, 11, or 12. Then you might move to dismiss the case, change of venue, permission to use cash collateral if engaged in business. Remember, we covered that in chapter 7. And for permission to use, sell, or lease property. And then they are also may file a motion to determine the value of collateral securing a claim. Debtor may move to exercise 11 U.S.C. 522F power, which is avoidance of a judicial lien, that we've covered once before in one of these mini lectures. I think it was chapter 4, the 04 lecture. And to avoid a non-possessory, non-purchase money security interest in certain household or personal goods. The debtor may not move to avoid a judicial lien when it impairing an exemption if a debt for alimony, maintenance, or support is secured by the lien. So motions after the order for relief, party and interest, the types of motion of party and interest, creditor, etc. They may move for relief from the automatic stay. For example, if foreclosure is pending and they're far behind, they aren't making planned payments, and might move for entry of an automatic stay so they can continue foreclosure action. For abstention by the bankruptcy court, to dismiss the case, to change the quick case's venue, to disallow a claim, to convert the case to a 7, 11, or 12, or for relief from co-debtor stay, and for examination of any person. I think that's a Rule 2004 exam. The Chapter 13 or the United States trustee may file an objection to the confirmation of the plan. If the debtor is a farmer, the bankruptcy court may not convert a 13 to a 7, 11, or 12 upon the request of anyone except the debtor. All right, so complaints after we did motions, now we'll do complaints. A debtor or creditor may file a complaint to determine the dischargeability of a debt, and Chapter 13 debtor who operates a business may file a complaint to collect accounts receivable or to recover possession of the property. A 13 trustee may file a complaint to exercise its avoidance powers, to avoid a lien, for example, and whether a debtor can exercise the Chapter 13 trustee's avoidance powers, and the courts are split on this, whether a debtor can. Hearing on the confirmation of the plan. When the plan is ready to be confirmed, it has to be held 21 to 45 days after the meeting of creditors. So they move things along really fast. The Chapter 13 trustee advises the bankruptcy court whether to or not to confirm the plan, and the bankruptcy court can decide on its own whether to confirm, and the plan has to comply with the provisions of 11 U.S.C. 1325 to be confirmable. Distribution of payments. If the plan is confirmed, the trustee will distribute payments to creditors in accordance with the plan. If it isn't confirmed, the 13 trustee will return the payments to the debtor less any unpaid administrative expenses. The plan can be modified at any time after the confirmation of the plan, but before the completion of payments, and the debtor, the 13 trustee, or an unsecured creditor may request the bankruptcy court to modify the plan. Revocation of the order of confirmation. So the plan is confirmed. Any party can request for revocation of the confirmation of order if it was procured by fraud, and it has to be filed with 180 days after the order of confirmation. And if the order is revoked, the case is converted or dismissed. So if the plan is no longer, if the plan was confirmed and the court revoked it upon complaint by made on request of the party in interest, the case gets converted or dismissed, and unless the debtor proposes a modification, that's standard. Full compliance discharge. After the debtor's made all the payments required by the plan, the court grants the debtor a full compliance discharge from his or her dischargeable debts, so long as the debtor certifies that all domestic support obligations that came due prior to the making of the certification have been paid, has not received a discharge in a prior case filed within 2 years for a prior Chapter 13 case and 4 years for a prior Chapter 7, 11, or 12 case, and the debtor has completed an approved course in financial management. So Chapter 13 has an income with 180 days credit counseling and outgo of an approved course in financial management. Bankruptcy court will not enter a discharge if it decides that there is no pending proceeding that might give rise to a limitation on the debtor's homestead exemption. So full compliance discharge continued. Unless a creditor timely files a complaint and prevails, the following debts are discharged. Debts for money or property obtained by false pretenses. So this is one of the things about bankruptcy, it's sort of a roll of the dice, Chapter 13. It might be a way to avoid problems. Nonetheless, it's up to the creditor to pursue those problems. Debts for fraud or defalcation while acting in a fiduciary capacity, that's the debtor, or debts for restitution or damages awarded in a civil case for the debtor's willful or malicious actions that resulted in personal injury or death to a person. So a complaint would need to go in there by those parties in interest that might be involved here, and in those cases, the full compliance discharge may enter, but these types of debts would not be discharged if the complaint prevails. If the complaint does not prevail, these get discharged. Also, there are some debts dischargeable in Chapter 13, but not in Chapter 7, which is one of the decisions that is going on in people's attorney's mind. Where should I guide my client to file? There's a debt for willful and malicious injury to property, as opposed to a person. They're discharged under 13, but under Chapter 7 they would not be. Debts incurred to pay non-dischargeable tax obligations. Chapter 13 would provide a discharge, where Chapter 7 will not. And debts arising from property settlements and divorce or separation proceedings, not to be confused here with the debts that are not dischargeable in Chapter 13, such as alimony or child support. So certain those that are not long-term obligations, your home or your home mortgage, that doesn't just go away because you finished a plan. You might still owe thousands and thousands of dollars on a home mortgage, and it rides through the bankruptcy. Even Chapter 7 is the same. Certain taxes are not dischargeable, and debts for most government-funded or guaranteed educational loans, and government benefit overpayments, debts arising from death or personal injury caused by driving while intoxicated or under the influence of drugs, and debts for restitution or criminal fine included in a sentence on the debtor's conviction of a crime. So a debtor will still be responsible for all those debts not fully paid under the plan, kind of returning back to that home mortgage. Just because the plan included catching up on the arrears and they kept the plan paid on time, that does not make the home mortgage go away at discharge. And there are other situations where there's some leftover debt, and plus there is the non-dischargeable debt, even though there's full compliance. The hardship discharge. A debtor who cannot make all the payments required by the plan may be granted a hardship if they don't complete the plan payments due to no fault on the part of the debtor. and to circumstances beyond the debtor's control. Debtors have, maybe there's disability or something that comes about. The creditors have received at least as much as they would have received in a Chapter 7, so they'll make that comparison. Chapter 7 is, we've seen already in planning discharge, we look at 7 a lot of times as possible. Modification of the plan is not possible for whatever reason. As you can see, injury or illness precluding employment is one of those reasons sufficient to modify a plan or may serve as the basis of hardship discharge. And it's a more limited discharge than the full compliance discharge. And it doesn't discharge any debts that are not dischargeable in Chapter 7 case. A discharge can be revoked within 1 year of the discharge after it's been granted, and a party in interest may request revocation of the discharge for fraud if the party did not know of the fraud until after the bankruptcy court granted the discharge, so it was revealed later. In closing the case, after the payments have been completed under the plan and the debtor has been discharged, the Chapter 13 trustee will file a final report and account. The trustee will certify the case has been administered fully, and if there's no objection received within 30 days, the trustee is discharged and the case is closed. And finally, there are sometimes the case may be amended without being reopened, so clerical errors in judgments, orders, and other parts of the record, or errors in the record caused by oversight or omission can be corrected, and a closed case can be reopened to grant relief to the debtor or to distribute previously undistributed property of the estate. So that's everything on Chapter 13. Thank you. Moving on to the next lecture, and take care. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.